The newly installed Executive Director of the Student Press Law Center. Welcome to our first webinar of the school year. It's a year of new beginnings. Many of you are new editors. For me, this is new too. I started as the Executive Director of SPLC less than 3 weeks ago, actually 3 weeks today, and I couldn't be more happy to be here. I want to introduce myself for a second. I come to this work as an activist and as a human rights attorney. I was on the school paper and the yearbook staffs in high school, but then after college and law school, I went on to live and work in over 25 countries around the world, working as a human rights attorney on issues of civil and political rights, including freedom of expression, gender equality, and the fight against discrimination. I come to SPLC with a deep belief in the power and the possibility of student journalism, of the need to enable students to speak truth to power, and the vital importance of ensuring that young people find and use their voice to document and engage on issues of civic importance. You are the front line in free press and the next generation of journalists, and it's really my privilege to join SPLC to work with you and to ensure that your voices are heard. As you know, SPLC has a long history of supporting and defending the student press in the United States. Founded in 1974, we're the only organization providing free legal help to student journalists and their advisors on issues related to censorship, copyright, digital rights, freedom of information, and so many other things. The things that we deal with are interesting, they're cutting edge, and today you're going to hear about some of our war stories and some of the ways in which we have and ways in which we can help you as you maneuver your way through this new school year. What are we going to do? We're going to spend about the next 40 minutes, or next 35 minutes, talking about some of the greatest challenges that you might encounter as this school year starts. We're going to focus on issues that have been on the forefront of the calls and the inquiries to our legal hotline, which has now been heating up since school's back in session. We hope that this is the first of what will be periodic webinars on relevant and exciting topics that can help you as you do your work this year. If you have topics to suggest, speakers to recommend, or questions to ask, you can tweet them to @SPLC throughout this webinar or later. Right now, what we're going to do is have two parts of our conversation today. First, we're going to have Jonathan Carter and Luke Perrin, who are the editors of The Technician at North Carolina State University in Raleigh, tell us how covering a recent student government meeting escalated into an open government controversy. And after they tell their story about what happened, real facts on the ground, we're going to have Mike Hiestand, who is part of the heart and soul of SPLC and who's the person behind our hotline, talk about some of the issues that may present themselves, the top 3 issues that may present themselves to you as this school year starts. So at this point, I want to hand it over to Jonathan and Luke to give them the opportunity to tell their story. Thanks. Gentlemen, it's all yours.
Okay, thank you very much. Hello, everyone. My name is Jonathan Carter. I am the editor-in-chief of The Technician at North Carolina State University in Raleigh, North Carolina.
And I am Luke Perrin. I'm the news editor at Technician at Raleigh, North Carolina.
So we're just going to briefly discuss what's happened the past couple of weeks. Luke was our main reporter at the student government meeting where this all took place. So I'm going to let him do a really brief recap of what exactly happened, and I'll tell you all what we've done in the days and the weeks after that and what we've done after the situation.
So to give you a little bit of background, this hearing was about an impeachment of a student body official. Student body treasurer John Taylor Willis was facing impeachment charges, and this was the preliminary hearing to establish whether there was probable cause to move forward with the investigation. At the hearing, which lasted about 2 hours, about an hour into it, after they had gone through and they had given statements and done a period of questioning, the session, there was a motion made to move the session into a closed session. And per the North Carolina Constitution, you have to provide a legal reason. There's 10 legal reasons that you can give to move into a closed session. And I was in the room, and I had the Constitution with me because I'd kind of heard rumblings that something might be happening along those lines. And I asked what the reasoning was, and the reason given was precedence. So I asked again, I said, per North Carolina law, you have to say one of these 10 reasons to kick us out. And precedence was the reason given again. Asked for a third time, got the same response. So at that point, I decided to sit there, and I said, "You're going to have to drag me out of here." And I was escorted out of the room, where they continued to deliberate on whether to move forward with the investigation for over an hour. We were not allowed back inside. At one point, they called the accused and the accuser back into the room to do further questioning, to which we were not allowed to re-enter the room during that time. And upon completion of closed session and moving back into an open session, we were informed that the vote was made during a closed session, which is also illegal. And the vote was not recorded. The vote was done on a voice vote. So there's no written record on who voted which way. And just to make matters a little bit more fun, they allowed visiting senators to stay in the room. So it wasn't even truly a closed session, because there were still members of the general public that were not a part of that committee that were permitted to stay inside the room.
Right. So while they were kicked out, they called me, and I came and I just waited with them until we got back into the room. And I was trying to put together all the puzzle pieces of what happened. And I learned that one of the student government advisors, one of the faculty members who is an advisor for student government, was kind of calling the shots and, not really leading the meeting, but she was kind of the de facto person in charge. And so after the meeting had concluded and when we had been let back into the room, I went up to her and I said, what was the exact reason that the public and members of the press were kicked out? She again cited the same thing she told Luke in the meeting, precedents. And I was like, there's got to be one of these specific reasons as to why you're going into closed session, per North Carolina open meeting laws. She just gave me precedents, cited me toward turned me toward the North Carolina State University General Counsel's office. And I, was like, okay, I'm not going to get anything else out of her. After that, talked with the news editors, talked with our advisor about what to do next. My next thing was I drafted an email to the SPLC explaining exactly what had happened, what we had done. I was contacted the next day by Mike Hiestand, and we, told him everything that had happened, everything that had gone on. So after that, and we have talked with the SPLC. The SPLC wrote an article about it. We've talked with other professionals and our advisors and stuff, and we have set up a meeting between us, our advisors who have been very helpful throughout this entire thing, the SG advisor who was kind of calling the shots there, and the members of student government who were in charge of that meeting. And I told the reporter from the SPLC the same thing I'm going to say now, that my number one objective to get out of this is that this doesn't happen again, that they don't kick out members of the public and the press for no reason again. And I in a perfect world would like for them to apologize and explain exactly why they did that. But my number one goal is just to ensure that this doesn't happen again. This year or next year, to any student reporters or to any members of the public that are illegally removed. We have not had that meeting yet. I have been promised, though, that we are going to have that meeting, but right now we're just kind of in a holding pattern. Can't really do much right now, and that's where we are right now. That's the situation.
That's great. We're working out the kinks in our system here. So thank you for telling that story. It's a really important story. I want to bring Mike Hiestand into the conversation. That's Mike right in front of you. He has one of the longest histories with SPLC. Came on board as a legal intern right around 1989, was our first legal fellow. Has been a staff attorney and is the guy who answers the phone, or at least responds to your online requests for consultations on our legal hotline. Mike, maybe you want to kind of pull out some of the legal issues from the stories that Jonathan and Luke have just relayed, and talk about how that might be part of what we're really looking at this year as the school year starts, in terms of the top 3 issues that students are going to have to really contend with as they get underway and continue the important reporting that they're doing. Luke and Jonathan, I'm going to ask you guys to mute your microphone, which is at the top of your screen, and we will and know that we can see you unless you turn the camera off. So don't do anything that would implicate you in any way. All right, Mike, I turn it over to you.
All right. Well, good morning from where I am, and good afternoon and good evening whenever everybody's watching this. We are real excited to be doing this. As Hadar said, I've been with the SPLC since 1989, and obviously when I first started, we didn't even have the capacity to do something like this. But yeah, this is all new, and we're delighted to be joining you, particularly at the beginning of the school year. First, Jonathan and Luke. I mean, these are the folks that are our heroes. I mean, simply by understanding what the law is and challenging both student government and, letting some of the school officials know what's going on. I mean, that's sometimes the biggest challenge. And just realizing that, that simply because they're doing it doesn't make it right. And understanding what your open meetings and open records law say before you go into the meeting, so that when they start doing crap like this, you're armed. You have the ability to challenge them in a knowledgeable way. As Hadar said, we're going to talk about kind of the top 3 reasons that college journalists call the SPLC, and freedom of information is always near the top of that list. And student governments, since I think it's probably worth talking about this because it is one of the issues that comes up a lot for college journalists. Student governments are a unique sort of body when we're talking about open meetings law and open records law. They're kind of a hybrid. I mean, there are certain open meetings or certain groups in a state, certain public agencies or public officials, that there's no question that they are covered by your access to information laws. Student governments are a little bit different. There are only, I think, 2 states in the country that actually specifically mention student governments as being among those public agencies that are definitely 100% covered by their open, by their FOI laws. In most states, they're not mentioned. There have been some court cases and things like that, or more likely attorney general rulings that have impacted this. But the way that we typically reach student governments is kind of by drawing, we start at the bottom and we look exactly at what the student government is doing, what the body is doing, what sort of responsibilities do they have. If they are purely just for show, I mean, and there are some student SGA groups that really don't do a whole lot of anything. If they don't have any sort of influence over the budget of the school, activity fees, anything like that, you're going to have a hard time probably arguing that they're covered by state open records or open meetings laws. But most student government groups, they actually do something. In most cases, they have responsibility for allocating student activity fees. The money comes in, it's collected by the school, and it's handed over oftentimes to the SGA for allocation. That turns them into a government body that's covered by one of these laws. Certainly the Board of Trustees and other groups within the university are going to be covered by the law. And when they turn their official powers, their official duties over to SGA to carry those things out, they in turn become a public agency as well, covered by these laws. So, and that's kind of the case in North Carolina. North Carolina student governments, they are involved in the process of allocating student activity fees. And as Jonathan and Luke said, when they meet to do that sort of thing, when they meet to conduct other school business, they are subject to the law just like any other group. So thanks. Yeah, good for you for challenging them. I hope that the meeting is productive. If it's not, you have our number and all that good stuff. And so one of the things I'm going to do now, speaking of having our number, is I'm going to just introduce you, I guess, a little to our website here. Kind of our 3 topics today before we finish up here is one to kind of introduce ourselves and the SPLC and to just let you know a little bit about what we do. We're also going to talk about the top 3 sort of reasons that people call us. I mentioned FOI. We're also going to briefly mention censorship. It's a little bit different at the college level, but it's always one of the #1 reasons people contact us. And copyright. There's some big stuff happening in copyright that I want to talk with you about. The other thing I want to mention, that the third sort of thing on my list is there are 2 things that I think that every student media program in the country ought to be doing right now. Maybe hopefully you've already done it, but if you've not, I'm going to clue you on what a couple of those things are. In fact, we're going to do one of them today, so we're going to get one of those things checked off your list. But first thing I'm going to do, and I'm going to do a little screen share here. and introduce you to our website. And the first thing I just want to mention is kind of, again, Hadar mentioned what we do, but one of our big tasks is to provide free legal help to high school, college journalists and advisors and people helping them. On our website, we have lots and lots of resources. I would say probably 95% of the questions that I get, we have over the years, put some sort of answer together for you on our website, and I'll talk about that in just a minute. But if for whatever reason you can't find that answer on the website, there are ways to get in touch with us, and I'll just point those out now. So just under the legal help button, there's two quick ways. If you have most of the calls, most of the things that come in aren't super urgent. You have a copyright question or perhaps just a general libel question or something like that. For those sorts of non-urgent questions, we encourage you to use our email form on the website, and we promise a response within 5 business days. We usually do a lot better than that. But again, for sort of non-urgent questions, for something that's a little bit more urgent, or if you just want to talk to a live human being, you can also schedule a phone call with me, and we can talk about it that way. If it's something that's super urgent, the cops are busting into your newsroom and they want to get photos or something like that, definitely give us a ring. We're open Monday through Friday, kind of regular business hours back in Washington, D.C. And hopefully we can get somebody to help you in a more urgent sort of timely basis. Okay, so now, as I said, there's lots of stuff on our website. And the first thing I suggest that you do is go to our legal guide session. And since we just finished with Jonathan and Luke talking about FOI, I want to point out kind of our access to records, meetings, and places page, because there's lots of good stuff there. In fact, one of the things that we have here down at the bottom is access to student government meetings and information. So it's a 50-state guide that kind of walks you through what we've looked at what some of the attorney generals have said, or if there's been any court rulings or anything like that. And we analyze the law and just say, this is how you approach student government, and these are arguments that you can make as to why they are subject to freedom of information laws. So that's a great little access piece. But we have lots of different things. So access to university foundation records. I mean, I don't know if you guys, I'm sure you do, but most public and private universities, they have these foundations that basically do all the fundraising work for them, and that's where the money is coming in. And there's lots and lots of money. And the question always is, do we have access to, do we get to find out where that money is coming from? Well, this is one of the guides that'll walk you through that. But again, lots of different sort of access guides that are available. The other one that I really hope that you will take a peek at, because I'm really proud of this one, is our Covering Campus Crime book. There are, and it's kind of becoming a big thing lately in the news, just, what sort of information are we going to be allowed to have access to in some of these campus courts and disciplinary proceedings involving sexual assaults. But the Covering Campus Crime booklet here is our best attempt to reconcile some of the federal laws that demand that schools, both public and private, provide some sort of information about campus crime, and the various state laws, the open records laws and things that we were talking about before. But it's a great, I think it's a wonderful resource, and the only one that I'm aware of in the country that's kind of put all this information together for you. The other thing I would, along that line, if you guys are looking for a wonderful sort of news tip, something to look at, we have put together this 10-step guide to auditing your school's compliance with the Clery Act. The Clery Act is that federal law that requires all schools, public and private, to provide at least some information about what's happening on their campus with respect to crime. A lot of schools, however, have not done their best in complying with the Clery Act, and so we have encouraged schools to do a compliance check. Is your school actually, checking off the things that it needs to do with the Clery Act? And we've put together this nice 10-step guide for doing that. That I don't know of a school that's used this that hasn't come up with some pretty interesting and revealing stories. So yeah, check that out. The last thing I will mention is another resource that I'm really proud about. That's one we actually started back in 1980s or 1997. Is our Freedom of Information letter generator. Every state in the country has an open records law, but they're all a little bit different. And so what our letter generator does is when you know that you want, for example, the parking ticket records that your campus police have put together. You want to see, what sort of scofflaws are out there. Are student athletes perhaps getting preferential treatment when it comes to parking tickets, which has been the case some places. You can use our little letter generator here, and you get the name of your campus police chief, and you just type in that I am looking for, a list of all parking records for the last school year. You put in his or her name and address, and you punch the button, and it actually prints out a letter that cites to your particular state's open records law and has all the different provisions and things in there that once you submit it, the law requires that they can't ignore it. The law requires that they either provide you with those parking ticket records or whatever records you're looking for, or point to the specific exemption in their state law that allows them to withhold the record. The presumption is under every state open records law that a record generated by a public official is supposed to be open unless there is a specific exemption that allows them to withhold it. And so the law does require that they point out that specific exemption. So again, a pretty cool little thing there. The next topic that I'd like to talk about is censorship. And censorship, and maybe I will go back so you can actually see me here. So censorship is actually it's a little bit different at the college level. It's always the number one reason that high school students call us. And for those of you that were in high school, you probably had issues with censorship. I mean, it's just kind of the way we unfortunately do business in this country, at least at the high school level. At the college level, things are fortunately different, at least for now. There have been some threats to college press freedom that are pretty troubling that we'll probably talk about in a future webcast. But for most public college student journalists in America, the law is pretty solid. You have the right to put out your media free from administrative interference. And when courts are looking at what exactly constitutes censorship, because the law really is pretty darn clear at the college level, colleges have gotten fairly creative, fairly subtle in some of their censorship attempts. So we don't see a lot of college presidents going in and taking copies of their newspaper off the news rack or calling up the printer and saying you can't print that. Those things do happen, but not certainly not as much at the high school level. And when they do happen at the college level, it's fairly rare. The sort of censorship that we see is really more subtle. But courts have made clear that they pay attention to any attempt by the school to punish or manipulate or to dictate and try and kind of mold the content in their student media. So we're talking about things like, firing your advisor or punishing your advisor, going after the school. The student media budget is a big way that schools sometimes get creative in their attempts to censor. So kind of put on a big, put your big glasses on when you're thinking about censorship at the college level. And, if you can show a direct tie-in between something that the college has done and your editorial coverage, that's probably something that the law would address and that we can talk about. I'm trying to think there's... Oh, I'm going to switch back to our screen real quick here. And for those of you that are private school students, A lot of what I'm saying when I talk about the First Amendment protecting the rights of college student media, a lot of that doesn't apply at the private school level. And so I will just point out, we don't have time to go into it right now, maybe in a future webinar we will, but this guide to private school press, you might not have First Amendment protection, but there are other legal avenues for protection that may be available to you. I mentioned there's two things that that I have always suggested that student media do at the beginning of the school year, kind of a back to school checklist I have put together over the years. The one bit, or one of the pieces I want to talk about today was what I call the talk. I think it's probably more important for high school programs to make sure they do this, but it's also come up occasionally at the college level, and so I think it's worth pointing out. But the talk basically is just an opportunity for your advisor to remind you that they are just that, they're an advisor. And at the college level, in fact, advisors are treated just like any other school official in terms of their ability to actually censor the content in student media. They're not allowed to. But advisors are there to support you and to help you along, and to when problems come up, they're hopefully there to provide some support. But at the end of the day, they are employees. They're employees of the school. And so one of the things I think it's always important for advisors to do is to remind their staff of that. As much as they want to cheerlead them on and help them out, there may come a point at which the advisor is going to be told that, look, you need to carry out these orders. You need to bring the paper to us for review before it goes to press, or whatever the sort of censorship act might be. There may come a time where they're going to be told by their boss they need to do this. And it's important for everybody to understand kind of what their role and what their function is. It's important that students realize that there may be a point at which, there should always be a point at which students are the ones to step up and actually take the lead in fighting any sort of censorship or any sort of conflict that comes up at the school. Students ought to be the ones that are calling the local media if there's any sort of censorship. Students should be the one to contact us at the SPLC. You don't want to put your advisors in a position where they are, being brought up on insubordination charges, and you lose your one main ally. So have that talk early on. Just remember that it's the student media, and students really do need to take 100% responsibility for making sure that things run smoothly. The last thing I want to talk about is copyright. And before we get into some of the substance of copyright, I want to let's check off the little second item I mentioned on my list of things you should do at the beginning of the year. One of the more interesting sort of topics that comes up in student media law as opposed to other law is the question of copyright ownership. When you work for the New York Times or the LA Times or some other traditional employee-employee, you have a traditional employee-employer relationship, the law is pretty clear. As an employee, anything that you create as an employee under what's called the work for hire doctrine belongs to your employer. So if you happen to work at a school where you are treated like a traditional employee and you have the same sort of benefits and access to resources and things as other employees, it may be that the work that you're creating, there may be some sort of ownership claim by the school. I don't know of any schools where that sort of traditional employer-employee relationship really takes place. Typically for student media, we're paid with stipends or scholarships or things like that. You're not paid a regular hourly wage that's compliant with federal minimum wage laws and all that kind of stuff. So it's typically not going to be a work for hire situation. So the question is, what sort of relationship is it, and who actually owns the copyright? For students, for the most part, student work, when a student takes a photograph or student writes an article, they retain ownership in that work. And so it's important at the beginning of the year to spell out, okay, if the students own the work, what sort of rights or license is the student passing on to the student media, so that they, obviously students are working to produce work for the student media, and that's everybody's media have the right to use that work. And so it's important, I think, to put something in writing, simply because the law is a little bit wishy-washy, and that we don't have really clear case law and anything that we can point to. So coming together and putting together what we call just a copyright agreement, which spells out whose rights, what rights belong to each of the different parties. Our model agreement is an attempt to kind of balance the rights of students to continue owning their work and to taking advantage of their work against the need of student media organizations to use that work and to use it reasonably. And so you can read through our model agreement and you can use it. You can, use it just as it is, or we encourage you to go through and really talk about this and to figure out, we, for example, in our model agreement, we say that the student is agreeing to convey a 3-month unlimited license to the student media to use the work. During that 3-month period, the photographer or the writer can't shop his work at a competing media source. That just makes sense. I mean, we don't want you taking a photo for the student newspaper and then going to the local paper and giving them that photo that competes and perhaps even scoops the student media that you're working for. Under our agreement, after 3 months, though, that reverts, and you can do whatever you want. You can shop your photo around and put it in your portfolio and do all that sort of thing. But again, take a peek and see if the provisions in our agreement make sense to you. But do it. It's important, because these things can come back to bite you in the butt later on if they're not spelled out. The last thing I would talk about on the copyright front is it's one of the things that has come up this school year, and maybe some of you have seen this already, is, I'll go back to my screen share here, is we've seen a number of cease and desist letters come in, these automatically generated cease and desist letters that are demanding payment, typically for images that you're using in your online content. It's become just a cash cow, I think, for a number of people, for attorneys and companies. What is happening, and you probably know about this more than I do, but images are being created now and embedded with codes that can be searched. And so if you go to a particular website and you pull down an image from that website, there may be a code in that particular image that once you post it on your website and you don't get the normal permission, you don't get a license, you don't have, you can't make a fair use argument for using this work. So you're illegally using this work. Used to be that, not a whole lot of people read the student paper online, perhaps, or the, Disney's not reading your work, or whoever's copyrighted information is not reading your work, and you're getting away with it. Well, now it just takes a Google search sort of thing for these companies to type in these unique codes, and they find out that, lo and behold, the student newspaper out in North Dakota is using our work, and I say they find out, it's a computer that finds out, and they're generating an automated letter that says, we found this work on your website, cease and desist using it and pay us $750. And honestly, it's a cash cow, because, if you've been caught, you've been caught, and there's not a whole lot that you can do about it. In fact, some of the times when people have written back to these companies saying, but, I did this, or we've used it this way, they just get another, automatically generated letter back just saying, we hear your concerns, but pay us $750. So, the time for using works online that you don't have the right to use is over. You really, really do need to be careful, because the technology has caught up to us. I think that's about it, and I think we're about out of time, and just some quick hits on things to think about as we start the school year. And I think I'll turn it back over to Hadar if you're ready.
Oops, great. Thank you, Mike. There is so much to do, and there are so many issues that are coming to light. Every conversation that I have and every opportunity that I have to talk with Mike about things that are brewing and hearing from the students who are kind of living the reality shows how much the resources that we provide are necessary and needed, and how much there is to do. We have so many resources available on the website. Mike really just scratched the surface, and even more in discussion about the issues that come up. Please use us, call us, follow us on social media, send us your ideas and your thoughts, and let us know what's going on the ground. I want to, as we wind up, thank Danielle Dietrich, SPLC's Publication Fellow, for her hard work in setting up this and yesterday's webinar, and to Diana Mitsu-Kloss, SPLC's Director of Engagement, for her support and her vision as we move these webinars ahead. Thank you to Mike, thank you to Jonathan and to Luke. We are a small but mighty team, but we look forward to working with all of you in the year ahead. There's lots to do, and we look forward to being sure that your voices are heard. Thank you all for joining. Please be sure to follow SPLC on Twitter at SPLC, on Facebook, and make sure you bookmark the SPLC.org website. Lots to do, lots of resources available, and we look forward to helping you as the year ahead unfolds. All the best. Thanks for joining us.